for Nucynta ER. The Nucynta ER periodic adverse drug experience reports, Nucynta ER periodic adverse drug events reports, periodic safety update reports, periodic benefit risk evaluation reports, the research abuse diversion addiction and reporting system reports, and the National Addictive Vigilance Intervention and Prevention reports. NAVPRO is the last.
Your Honor, Mr. Ottaway and I discussed this briefly right before we started. I don't anticipate an objection to certain of those reports. All I ask is that we lay a foundation for what maybe the different categories of these types of reports are with the witness to establish that they should all be admitted into evidence. There's some that recognize that I know we're not going to have an objection to, but there are others that I believe we certainly need a foundation laid with the witness as far as what it is.
All right. Well, what I'll do is I'll allow you to introduce them, publish them.
And if I have call-outs, I will probably have them marked as an A, B, C, or D to a given exhibit.
Sure. And then as you use specific ones, I can make a determination on whether or not they're admissible at that time.
For example, the NDA for Duragesic contains multiple volumes, and it's listed as exhibits J2652 through J2842. So that's why the number of exhibits is so large.
Gotcha. All right. Thank you. Would you like to call your first witness now?
We would call Bruce Moskovitz to the stand.
Good morning. Would you please raise your right hand? That's where you are. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Would you please state and spell your name for the court reporter, please?
Yes, it's Bruce Moskovitz, Moskovitz.
It is Dr. Moskovitz.
Yes.
You are a medical doctor.
Yes, I am.
Can you please briefly tell the judge and your educational background?
Yes. After graduating high school, I went to Boston University, undergraduate and medical school, 2 years of undergraduate, 4 years of medical school.
And receiving your medical degree, did you then do some postgraduate education?
Yes, I did.
Can you tell Judge Bachman about that, please?
Yes. Once I finished medical school, I did my internship, 1 year residency, 2 years internship and residency in internal medicine, and then I did a fellowship in infectious diseases for an additional 2 years, all at Hartford Hospital in Connecticut.
Did you receive a board certification?
Yes, I did.
Can you tell Judge Bachman in what you are board certified?
I'm board certified in internal medicine.
Dr. Moskovitz, where do you live?
I live in Lambertville, New Jersey.
This is Judge Bachman. I'll introduce you. You'll be testifying before him. The person right there is Angie, and she is taking down every word you say. I speak softly. You speak quickly. So you need to slow down, and I need to speak up. Fair enough?
Fair enough.
Having graduated from medical school, your fellowship and residency, having been board certified in internal medicine, what did you do?
I started my internship and residency. After my internship and residency, I joined the pharmaceutical industry.
And can you please tell us your experience in the pharmaceutical industry just up until the time that you took a job with Janssen?
Yes. After I finished my fellowship in infectious diseases, I joined Hoffman-La Roche, where I was a senior physician developing anti-infective compounds. I was with Hoffman-La Roche for approximately 3.5 years. At that point, I left Hoffman-La Roche and joined Rhone-Poulenc Pharmaceuticals. Rhone-Poulenc was...
Could you spell that for us?
I'm sorry?
Could you spell that for us?
Yes, Rhone-Poulenc is RHONE-POULENC. Rhone-Poulenc Pharmaceuticals was new to the United States. They were doing the very earliest trials of a compound that was discovered by the Pasteur Institute in France to treat what subsequently came to be known as AIDS, HIV/AIDS. They had a compound that very early on they thought showed some evidence of efficacy, and
When you say efficacy, what do you mean?
that, well, this was before the virus itself, the human immunodeficiency virus, was isolated. But they thought that they had some evidence that it lengthened the life. At the time, a diagnosis of AIDS usually meant a lifespan of months to a year. And they thought they had a compound that could reduce the number of opportunistic infections and lengthen a person's lifespan. And so we were the first in the United States to study a compound for AIDS.
Now, what did you do when you were at Hoffman La Roche?
I worked in the anti-infective group, and we developed anti-infective compounds. We brought one to market that was Rocephin. The generic name is ceftriaxone.
Did
We'll
the
need you to spell
product-
that too, Doctor.
Yes, I'm sorry. Ceftriaxone is CEFTRIAXONE.
And then you were telling the judge about working on this compound with
Poulenc.
Rhone-Poulenc. You'll excuse my French, I'm not any good at it.
That's okay. I was with them for 5 years. I had French lessons almost daily, and I never got it.
Did the drug you were working on with that company ever come to market?
No, it did not.
What caused you to become interested in working for a pharmaceutical company instead of pursuing your internal medicine profession?
Well, as I said, I had a fellowship in infectious diseases, and when I was completing my fellowship, the program that I was in at Hartford Hospital, we were approached by, I believe it was Merck at the time, because they were looking for a physician to join their clinical research group, and the director of my program asked me if I was interested. It was kind of serendipity. But I took a look at what the opportunity was, and I found it to be very interesting. It was an opportunity to interact with experts, specifically in the field that I was interested in, infectious diseases, to bring new compounds to the market, to bring new compounds that would make a difference in individuals' lives. And so on my own, I started to look at other opportunities and eventually settled on Hoffman La Roche as a company that I joined.
Working with Hoffman La Roche and Rhone, did you become familiar with the FDA approval process for drugs?
Yes, sir.
You say the drug that you were working on for Rhone was never approved by the FDA?
That's correct.
It was a drug to restrict opportunistic infections in what later became known as AIDS patients?
Yes, that was a drug that was called HPA-23. Actually, a little interesting background. There were individuals who went to France. Rock Hudson went to France specifically to get that drug.
Okay. So what did you do after leaving Rhone?
I joined Johnson & Johnson, Janssen Pharmaceutical,
What year was that?
1990.
We've heard that one of the drugs discussed in this case, Duragesic, was marketed in 1990-91.
Yes,
Are you familiar with that?
yes, I am.
All right. Can you tell us what you did when you went to work for Janssen?
Yes, for the first 10 years, I was on the research and development side. I was responsible for development of anti-infective compounds, most specifically an antifungal compound that treated fungal infections in individuals with HIV and AIDS.
And did you continue your work and interest in AIDS up until this day?
Yes, I do.
Can you tell the court what you do in that regard?
Yes. I sit on I am a trustee. I sit on the board of trustees for the Hyacinth AIDS Foundation in New Jersey. It's probably the largest organization that provides treatment, social services, education, and advocacy around issues of HIV and AIDS.
Now, you say you went to work for Janssen Research.
The Janssen Research Foundation, that's correct.
Can you explain to the court what the Janssen Research Foundation is?
Yes. The Janssen Research Foundation was the R&D arm in the research, the research and development arm. In brief, we would be responsible for the clinical development of an identified compound, primarily through what are termed phases 2 and 3, doing ultimately the pivotal trials that would be then filed, the data would be filed with the Food and Drug Administration, and the data would allow the FDA to make a determination whether the benefits of the drug that we were exploring outweighed the risks of the drug, and ultimately, if they decided so, they would approve the drug, and then we could sell it.
Now, you indicated you were working on antifungals.
That's correct.
Did you work on other drugs in development while you were with the Janssen Research Foundation?
Yes.
Can you tell Judge Bachman about that?
Yes. I was brought in to head up the anti-fungal area, but at times during my stay with the research and development group, we had allergy drugs, gastrointestinal drugs. So there were a variety of other compounds that I touched during that period.
Now, what happened after, you said you were with that organization about a decade?
Yes.
What did you do after you finished your tenure at the Janssen Research Foundation?
In 2000, I was asked to join the medical affairs group, specifically to head up a pain group within the medical affairs group.
Now, the court's already heard about the various parts of Janssen, both back then and now, but can you briefly tell him what the medical affairs group does?
The medical affairs group, in contradistinction to the research and development group, is primarily charged with managing compounds that have been approved, that have come to market, to develop additional data that we've identified through discussions with experts in the field. The phase 2 and 3 studies have a very narrow focus. They're generally, depending upon the therapeutic area, they're generally going to be blinded, which is to say that neither the patient nor the physician knows what the patient is getting. Placebo-controlled studies, where one arm gets a placebo that looks like the active drug, and the other arm would get the active drug. And that helps the FDA make a determination of whether the drug has efficacy. But there are far more data that are needed to provide to a treating community. For example, even at the most basic level, they're not particularly interested in hearing that your drug is better than nothing, than a placebo. So some of the trials that the medical affairs might do would be a controlled trial against an active compound, something that they're using. They want more information about different age groups, about different outcomes. If I use the drug, what are the financial implications of it? Activities of daily living, functional outcomes. So there's much more data that the medical affairs group would continue to develop around the compound, while the R&D organization would generally then move to other compounds or new indications for that compound.
Does this data include information on the risks and benefits of the drug being examined?
Yes, but that's not solely the role of medical affairs. Any data that are developed, whether it be through the R&D organization or the medical affairs organization, and that includes worldwide, would go into an assessment of safety and efficacy for the drug.
Why would Janssen care about additional data on a drug it's already got to market?
Because there are data needs, because we are asked to provide such information. Going back to some of the examples I gave, we want to know about the utility of the drug in special populations against other compounds, and information that goes well beyond just the straightforward question of efficacy and safety. But even when we speak about safety, keep in mind that the phase 3 trials, the pivotal trials that are done to bring the drug to market, are done in a relatively small number of individuals. Depending upon the compound, that may be several hundred to several thousand patients. We would learn of the adverse events that would occur with the greatest frequency in that number of individuals enrolled to the phase 2-3 trials. But adverse events that are much rarer would only be seen after the drug is marketed, in larger trials or in larger use.
And what was it in your background, Dr. Moskovitz, that qualified you to take this job in medical affairs?
Well, given the fact that I didn't have specific training in pain management, but I managed my group well. I had broad experience in several therapeutic areas, even on the research and development side. And at the time, I was asked to build a new group within medical affairs. And so I had the organizational skills. The vice president of medical affairs at least thought so.
And you say you took that job in the year 2000?
Yes, sir.
Now, in the year 2000, did Janssen have an opioid prescription medication on the market?
Yes, we did.
And can you tell the court what that product was?
Yes, that was Duragesic.
So you come over, you've got this new group, the pain group, you said? Is that...
That's correct. Well, technically it was pain and mycology, because I still had in the portfolio that I was responsible for the antifungal compounds that I had been working with.
Angie's looking at you like, how in the world do you spell mycology?
It's with a Y, M-Y-C-O-L-O-G-Y.
Okay, please try to remember, if you use a word that most folks aren't familiar with, to turn and spell it for the court reporter.
Yes, forgive me. This is just second nature to me. So.
Now, you say you had a product already on the market when this group was begun. Was someone responsible for that product before you took it over?
Yes. It was being managed in another group within medical affairs, the neuropsychiatric group.
And did you have a title as you took over the management of the pain product for Janssen?
Yes, the title changed over the course of the years. I believe it when I entered, it was group director. Later on, it became therapeutic area head.
At some point, there are additional drugs that are going to come under your purview.
That's correct.
Can you tell the court what those drugs were?
There were additional drugs within the pain area, but we also managed some of the drugs that were in other therapeutic areas, such as gastrointestinal.
Well, let's restrict our conversation today to the pain area, if you will, and tell the judge what other products ultimately ended up under your purview.
In 2004, the medical affairs groups of Janssen and Ortho McNeil merged, and so we started managing the tramadol compounds that Ortho McNeil had brought to market. And then later on, after Nucynta, tapentadol, was approved, we took over the phase 4 research with the compound tapentadol.
Now, you say Ortho McNeil merged with Janssen?
Well, the medical affairs groups did.
All right. And what products did Ortho McNeil have in its portfolio?
Within the pain group, it was tramadol, which was Ultram, tramadol with acetaminophen, Tylenol, and that was Ultracet, and subsequently an extended release formulation of tramadol, which was called Ultram ER, was developed and was within my portfolio.
The court has heard testimony about a drug called Nucynta and Nucynta ER.
Yes.
Can you tell the court when that came under your purview, if it ever did?
Yes. The drug, the Nucynta, the immediate release formulation, was approved in 2009. And so on a technical basis, we had responsibility in 2009, but we were involved far earlier than 2009 in some of the work that the R&D organization,
R&D,
meaning research and development, that was doing in bringing the drug to market. There was a team, and the team would include medical affairs because we provided input to even the phase 2 and 3 studies that would be done.
Ultimately, Nucynta and Nucynta ER were approved by the FDA?
Yes, both were approved, and subsequently Nucynta ER had an approved second indication.
What was the approved second indication?
Well, the primary indication was moderate to severe pain, persistent pain, and the second indication specifically was diabetic peripheral neuropathy. Neuropathy, Neuropathy.
Thank you. So after all of these drugs are finally approved and they're on the market, what are your responsibilities in medical affairs for them?
Well, within medical affairs, we were responsible for additional clinical trials if we thought that they would provide useful information. Within medical affairs, we had groups that continued to collect adverse reactions, any safety data that were developed. We had a group that would respond to physicians if there were questions about any of our compounds. We had a group that would be responsible for measures that might not be discovered only in clinical trials, something like outcomes research, where they might access large databases to answer a question of interest.
And we're going to go into some of that later on, Dr. Moskovitz. But are you still with Janssen?
No, I'm not.
Tell the court what happened with Janssen and when it happened.
I retired in May of 2011.
What do you do now?
Enjoy life. I continue to be active on boards of trustees. I travel. I enjoy some physical activities, but generally stay involved with some community activities as well.
Well, clearly you're here today, and is it because Janssen has retained you as a witness to testify in this case based upon your training and experience?
Yes, sir.
As Janssen's former head of therapeutic area regarding pain, are you prepared to testify about the drug approval process, post-marketing surveillance program for Janssen's opioid products?
Yes, I am.
Are you prepared to testify about safety reviews that examined Janssen's opioid products?
Yes, sir.
Are you prepared to testify about reported adverse events associated with the use of Janssen's opioids, including abuse, misuse, and diversion of those products?
Yes, sir.
Are you prepared to testify about preclinical, clinical, and post-market research conducted on those products?
Yes, sir.
Can you speak to the scientific support for statements Janssen made regarding the risks and benefits of those products?
Yes, sir.
Are you familiar with the clinical trials conducted and sponsored by Janssen regarding those products?
Yes, sir.
And having worked with them, are you familiar with those opioid products that Janssen manufactured and sold in the United States?
Yes, sir.
Are you prepared today to discuss with Judge Botman Janssen's efforts to reduce in its products abuse, misuse, and diversion?
Yes, sir.
And are you familiar with the FDA process for application, approval, and marketing of those products?
Yes, sir.
We would offer Dr. Moskowitz as an expert on those subjects.
Your Honor, our only objection is to the extent we're going to get into the drug approval process and how that works with the FDA. It's not relevant to this case, as we've said, but it's not to its qualifications, it's to the relevance of the testimony.
Certainly we'll allow you to state that objection, but perhaps at a different time. I will go ahead and recognize Dr. Moskowitz as an expert in those areas, Mr. Ottaway.
Thank you, Your Honor. And we'll be offering your opinions later on, Doctor, but we broke off talking about medical affairs, and you were talking about the different groups in medical affairs. Did you put together a graphic with us that would describe to the court how the medical affairs group is divided at Janssen?
Yes.
And can you please explain, using that, to the court what you were describing for us before I offered you as an expert?
Yes, sir. The Vice President of Medical Affairs would report into the President of Janssen. Within the medical affairs group, we had several therapeutic areas. In addition to pain, there was a therapeutic area, as we spoke about, for neuropsychiatry. Within my group, we had clinical research associates. Well, let's start with the left side. Clinical research, I hired physicians who had specific expertise in the area of analgesia. They would...
Was one of those people Dr. Vorsanger?
Yes, Dr. Vorsanger
We'll
was...
hear from Dr. Vorsanger later, but
Yes,
that's
sir.
where he fits in.
That's correct. I hired Dr. Vorsanger, and he fits under clinical research. They would be responsible for new clinical trials and interacting with the R&D group. Clinical research associates, these are individuals who manage the logistics of new clinical trials that we might anticipate, finding investigators, contracting with those investigators, or with outside contract research organizations that would manage those clinical trials. We also had a group of medical science liaisons. These were scientifically trained individuals, PharmDs, who would interact on a scientific basis with experts in the field of pain to understand what their concerns were and to share data with them. There were other groups within medical affairs. I mentioned outcomes research. That was the group that assisted us in some of the clinical trials, but independently they would be working to look at outcomes that went beyond straightforward efficacy and safety. I mentioned before pharmaceutical.
When you say efficacy, again, what do you mean?
The determination whether the drug is effective for treating the indication for which it's approved.
I'm sorry, I interrupted.
No, that's fine. So the outcomes research group will interact with many of the databases, or they'll help us with putting in other measures in the clinical trials we do. And there was a medical services group, fairly large group. This is the group most often staffed with PharmDs. These are doctorates in pharmacy. They had the primary responsibility for the intake of any adverse event report on any of our compounds. They would also be responsible for reviewing the literature, specifically to determine whether there were any adverse events reported in the literature. They were also the group to whom questions about anything on our drugs would be directed if it came in from the medical community. So if a physician called in and wanted more information about the use of Duragesic in treating low back pain or some outcomes measures, those inquiries would go to the medical services group, and they would respond to that with a literature review and provide balanced information on the benefits and risks relative to the specific question that was being asked.
And did that happen on a regular basis? People calling in and asking about the drug?
Oh, absolutely. Absolutely.
Can you give the judge some idea of how often that would occur?
On a daily basis, they would get questions every day that they would respond to.
Now, you've talked about your involvement in the pain area. Roughly how many people worked with or under you as the medical affairs person in charge of the pain area?
Oh, it varied over the course of the 10 years. I had one or two physicians who would work with me. We would have 3 to 5 clinical research associates and 4, 5, or 6 medical science liaisons.
You indicated that you were familiar with the process by which these drugs were approved. If I say the term NDA, does that have meaning to you as a person that was in charge of Duragesic or Nucynta?
Yes, of course.
And can you explain for the judge what the NDA on a product is?
Yes. At the completion of the R&D process, the research and development process, the drug has now gone through what is termed the phases of development, phase 1, phase 2, phase 3, where phase 3 typically is the phase in which the pivotal trials, the pivotal trials of efficacy and safety are conducted. And all of the data, going back to all of the development data, the preclinical data, the pharmacokinetic data, the animal models that were used to show an effect of the drug, the early trials, the first in-human trials, the phase 2 trials, which are preliminary trials to look at issues of efficacy and safety, and finally the pivotal trials would be provided completely to the Food and Drug Administration for their review in a new drug application.
And was that true for Nucynta, Duragesic, and Nucynta ER?
Yes, it was.
Are these NDAs kept on file with the FDA?
Yes, they are.
Okay, and they can be quite lengthy, can they not?
Yes, they can. Before the advent of electronic records, when I was at Hoffman LaRoche, for example, we would send the data in 1 or 2 large moving vans to the FDA.
The court has in front of it the NDA for Duragesic comprising 64 volumes. Fortunately, he doesn't have to deal with it in paper. It's on a thumb drive in front of him. And at this point, Your Honor, we would offer the NDA volumes for Nucynta IR, Nucynta ER, and Duragesic, which are contained on the sheets in front of you in multiple exhibit numbers, summarized on the sheets that I gave Mr. Pate in the court earlier.
There's a lot more on these sheets than just the NDA files, Judge, so maybe we get some clarification. You're only offering the NDAs at this time?
I think these two are the NDAs. They may have different descriptions on it, but I think they're the NDAs. I'm going into the other ones here.
You're only offering.
Well, right now, I'm general.
Again, Your Honor, our objection is to the relevance of the NDAs.
I overruled the objection. I'll allow for them to be admitted into evidence. And we can clear this up perhaps on a break, but on the sheets you gave me, it starts with exhibit number J2652, and it seems to go in numerical order all the way to J2842.
Yes, Your Honor, it's not exactly because there's one J2652 and then it jumps to 792.
You're correct, but yeah, so it's J2652 and then J2792, and it seems like after that it does
Right,
go.
up to that, to J2842.
Okay.
And the Nucenta goes from J2681, skips to 702, then skips to 2713. It's at SEC. It's on
And
the
it goes from
second
2713 all the way.
14, 15, and then goes 2703, 4, 5, 6, 7, 8, 9, 10, 11, and 12.
We'll clear that up maybe on a break, but I will overrule the state's objections and allow them to be entered into the evidence.
We're going to have to get through a few more acronyms for the court reporter in the court as we go forward that we're going to refer to later on, Dr. Moskowitz. So if I can have you tell me, if you can, if I say PSUR, the acronym PSUR, what does that mean?
Periodic Safety Update Report.
And what is that exactly?
When a drug is approved under FDA regulations, the company continues to provide the Food and Drug Administration with all available data about the safety of the compound on a regular basis. It's more frequent early after the approval, and later on the frequency drops off.
Is this something the FDA asks you to do?
It's a regulation. We must do it.
All right. And did you do that on Duragesic and Nucenta and the products that you had under your control or purview at the therapeutic pain area?
Yes, and the PSURs were managed through the regulatory group.
Now, what is PADER? That ring a bell?
Periodic adverse drug, I'd have to look at what.
All right. The periodic adverse drug event report, maybe?
Yes.
Okay. And is there another one that you're familiar with? PBRER?
Sorry?
PBRER?
I don't recall what the acronym is.
How about NaviPro?
Well, I know what NaviPro is. I couldn't give you what the acronym is. They were a group that did surveillance for us over our products.
All right. And was there a PADR and a PSUR, as you've described, for both Nucenta and Duragesic?
Yes.
We'll get into those a little later. Those are also contained on the exhibits we've offered, Your Honor. Summary lists, starting with the Nucenta PADER at 1392, the Nucenta IR PADER starting at J1121, and the Duragesic, the Navipro starting at J1310.
Are you law firm those right now?
Yes.
Well, I don't think the numbers run consecutively.
They don't. That's why I gave the court a list and counsel a list. And I'm only offering the ones on those sheets.
Well, as far as the PADER, I don't think we had any testimony yet on what exactly that is. He told us what the acronym was. I appreciate, but we don't know what the reports are, who they're reported to, whether it's a regulation or anything like that. And similarly for Navipro, I think the only answer related to that was that it's a group that did some surveillance. And there's no context for what these reports are, whether they should come into evidence at this point.
We're going to go into this. I'm sorry. Go ahead.
So it lacks foundation at this time to offer the exhibits.
I'm sorry. Can you answer Mr. Pate's question and tell him what Navipro is and where it reports to?
Yes, Navipro was a group that conducted some surveillance activities around tapentadol, and these surveillance reports did become part of the periodic reports that we would make to the Food and Drug Administration to determine rates of abuse, misuse, diversion of our compounds. It was one of the surveillance programs that we put in place around our compound.
And then there was a question raised about what is PADER and how is it used. Can you please answer that question?
Again, there too, we're dealing with events of interest that are filed to the Food and Drug Administration on a periodic basis about safety of our drugs.
And again, we would offer those with that additional explanation of the exhibit numbers contained on the sheets that I've given counsel and the court.
These are for the Navipro and the Nucynta ER, PADER.
PADER, yes.
Just there's something you.
The ones here on this sheet, Your Honor, that are...
I'm not trying to be difficult.
No, you're
I'm
not
just
being
trying to follow
difficult at
along.
all.
There's a lot of sheets here, with lots of exhibits on them.
Yeah, it's IR and ER, but they're on two different sheets here. Right.
I will admit those exhibits into the evidence again. We will clarify those, but there's exhibits that have to do with Navipro, Navipro, Nucynta ER, PADER, and Nucynta IR-ER NDA.
That's correct, Your Honor. As usually, you've said it more succinctly than I did, so.
I got the benefit of hearing you first.
One last one, Dr. Moskovitz, and hopefully we can move on and let you tell the court what you came to say. When I say radars, what does that mean to you as someone with experience in this area?
Yes, the Radars was an independent group that performed surveillance across surveillance through several means to assess risks of abuse, misuse, diversion of our compounds and other opioids. I believe the acronym is Researched Abuse and Diversion. You'll have to give me the last two. Somehow I always get hung up on those.
Research, abuse, diversion, addiction.
Addiction-related
Yes.
services,
Yes.
yes.
And are those kept by you as the head of the therapeutic pain area?
We would be reviewing those. They would be kept primarily within the safety group of Janssen.
And is that something that you all use to follow these drugs and learn about them? The data that you were talking about when you were telling the court about collecting data within the medical affairs group?
Yes, so in addition to the routine safety data, the information that would be filed on the routine safety data, we had several programs in place to monitor different aspects of risks associated with abuse, misuse, diversion of our drugs.
How often are these reports generated, and what do you do with them?
Most of the reports are generated on a quarterly basis. We would review them internally. We would also review some of these reports with external groups. And ultimately, we would make decisions about whether we needed to intervene in some way, for example, make a change to the labeling. But all of these data would be submitted to the Food and Drug Administration.
And were they kept by product type? For example, we know Duragesic is a fentanyl product. Are they specific to a product or the active ingredient in that product?
Most of specific to the adverse event reporting, we would be collecting data on Duragesic. Occasionally we would get information that couldn't specify whether it was Duragesic, and we would still report on that. Some of the other sources of information and some of the other surveillance could be specific to Duragesic or might not be specific to Duragesic, and would simply report on the compound fentanyl.
Now, there has already been testimony in this case about the RADARS program, and we're going to go into it a little later on, but I have listed and provided the court a summary of the RADARS system data, starting at J1027, that we are going to discuss today. I think the first one is dated in 2007, the last one in 2014. And I would offer that those exhibits at this time.
Object to hearsay on the radar reports, Your Honor. This is not an internal system that they use to monitor. These are not their reports. These come from an outside source that are reported to them. As far as I know, we don't have any sort of affidavit from them. They're not here to be cross-examined on this, so these reports are hearsay.
These reports are kept in the regular course of business by Janssen and provided as the witness has indicated.
Your Honor, if he's suggesting that they're business records, they have to be made by someone with knowledge of the events or conditions at the time in court. And there's not a Janssen witness who can testify to that because these do not come from Janssen. They may make them, they may keep them, but they don't make them.
I overruled the objection. I'll allow for the RADARS exhibits to come in. Those begin with J1027. They're not in any type of numerical order, but the last one I think is J1718.
Thank you, Your Honor, and I apologize for the numbering system. We'll get it worked out at the next break. Now that all of those are in, Dr. Moskovitz, I want to continue our discussion. Do the different therapeutic groups interact with one another?
Yes, very much so. And we also interact with various groups throughout the rest of Janssen, including the research and development organizations.
Have you covered with the court the various groups that have fallen under your control as the medical affairs person for the therapeutic pain area and the groups you would interact with?
Well, this isn't a complete schematic of other groups we would interact with.
Can you give the court some idea of other groups that you would interact with in the medical affairs area?
Certainly. We would be interacting with the research and development group. We would be interacting with the regulatory group, with sales and marketing, with the biostatistical group, the clinical pharmacology group.
Some of those we can figure out. Research and development, you've already told us about. Regulatory, we've heard evidence about in the case, but what is biostatistical?
They would provide guidance for such things as the number of individuals we might need to enroll to a clinical trial. They would do the statistical analysis after the trial is completed.
I'm sorry, I stopped you at sales and marketing. Tell me about that.
We would be interacting with our colleagues in the sales and marketing group. For one thing, we learned from them some of the concerns and questions that might come from the healthcare community. We might choose to answer some of those concerns with a clinical trial or with a database analysis. So it it kept us apprised of what was going on in the field and what are the concerns that are being raised.
The court has heard some testimony in this case about something called the Promotional Review Committee.
Yes.
Can you give us a little, can you drill down on that for us and tell us what it is?
I can. Before information can be shared under the guidance of the Food and Drug regulations with a physician that a sales representative is seeing, the Promotional Review Committee would review any of the materials that would be considered to share with the healthcare provider. The Promotional Review Committee was comprised of the Medical Affairs Group, the Regulatory Group, the Legal Group, Medical Services. So there was a broad review of these materials, and only after these materials were approved could the promotional piece be used with our sales representatives.
And did you submit those kinds of materials to the FDA?
Yes, under regulations, we had to submit all of those materials.
And that's submitted on, I think the court's heard Form 2253, if I'm not mistaken.
I believe that's correct.
Did you play a role on the Promotional Review Committee?
Yes, sir.
Can you tell the court what role you had played while you were at Janssen on the Promotional Review Committee?
Yes. Medical Affairs had a seat at the table, and during Promotional Review Committee, either I or one of the individuals, one of the physicians reporting to me, would sit on the Promotional Review Committee and review any of the pieces that were being considered for promotional use.
During the time you sat on that committee, did you believe the materials that you submitted were fair and balanced as to the risks and benefits of the drugs that you were discussing?
The materials that were approved, yes.
All right. Now, let's go back to the drug development and approval process. Janice, can you put up a graphic for us? This was used in opening, Your Honor. It's the one we used in opening. Oh, no, it's different. Do we have that one for hearing and the court? I have this sort of quote in my opinion. It's quote exhibits from another.
Thank you.
Thank you.
Can you tell the court what we have on the screen now?
Yes, sir. Let's start at the top where we talk about FDA approval. Ultimately, the intent of the development program is to allow the FDA to review our data and make a determination whether the benefits of the drug in the intended use outweigh the risks. All drugs have risks associated with them, and some are very serious risks, but ultimately the FDA is going to determine whether the benefits outweigh those risks. We start off with understanding a patient need. What is unfulfilled? In what way might there be an improvement that we can bring to market? And patient needs drive the decision to bring a compound into development. Once the decision is made to bring the compound into development, there will be a preclinical period where we'll learn in a non-human setting, in animal models, information about the drug, what's the mechanism of action. In animal models, what are the likely adverse events that we might see in humans? What are the pharmacokinetics? If you need me to spell that.
That one's actually spelled on the board there if you need a little help.
Okay. And so we'd have that information to help us determine whether to move ahead with the compound and what the initial doses we might bring into the first in-human trials.
Are there drugs in development that never make it past that part?
Many of them never make it past that part.
Okay, what happens if they do manage to make it past that particular phase?
Okay. Then we move into phase 1 testing. Typically, these studies are done in normal human volunteers. That may not always be the case, but typically they are. We would be looking at pharmacology. How does the drug work? We would be looking at pharmacokinetics. And
what does that mean?
Pharmacokinetics generally is divided into what we call ADME, ADME, absorption, distribution, metabolism, and excretion. So we're trying to learn about how the drug is absorbed or gets into the body, distribution once it gets into the body, where does it go in the body, metabolism, most drugs before they're excreted are changed in some way, oftentimes in the liver, and excreted, how does the drug leave the body? In many instances, that's going to be through the urine. It could be through breathing, through the vapor, could be in stool. So those are the specific areas of pharmacokinetics. But that helps us determine what are the doses that we now want to bring into the phase 2 studies.
About how many people are involved in a phase 1?
Fairly limited number of individuals. It usually is anywhere from 20 to 100 individuals.
And are there drugs that never get past that phase?
No, absolutely. We might learn, even in a normal volunteer population, of adverse events that would not allow the drug to proceed.
Okay, if it makes it past the pharmacology and pharmacokinetic portion of a phase 1 test, what happens next?
In phase 2, these are preliminary efficacy data. Now we're going into a patient population, a highly selected patient population with respect to the inclusion and exclusion criteria that we would allow in the study. It gives us a preliminary assessment of how effective the drug is, what are the best doses to then take into the pivotal large phase 3 trials.
Are there drugs that don't make it out of phase 2?
Yes.
And roughly how many people are involved in a phase 2 study?
This would vary considerably depending upon the compound you're looking at, but generally we're talking about 100 to 300, maybe 500 individuals.
If the drug gets out of phase 2, what happens next?
We move into what we term the pivotal phase 3 trials. These are the trials that ultimately would allow the FDA to make a determination whether the benefits of the drug used in the specific indication that we're studying in the pivotal trials outweigh the risks that we know we'll see in the pivotal trials.
About how many people involved in a phase 3 study?
Here too, it's huge variability depending upon the compound, but this typically may be anywhere from several hundred to thousands of patients.
Are there drugs that do not make it past a phase 3 study?
Yes, sir.
Roughly how long from the time you just described seeing the patient need and getting through phase 3 does it take?
Again, depending upon the compound, this may be anywhere from 5, 6, 7 years to 10 years or more.
You've talked about Nucynta. Can you put a face on that for us? How long did it take to get Nucynta from patient need through phase 3 based on your memory?
I don't recall specifically when our partner Grunenthal began isolating the compound. but it was in the early 2000s, and ultimately the NDA was approved in the late 2000s, 2009 for the immediate release, 2011 for the extended release.
So roughly a decade.
Roughly a decade.
What happens after you get out of phase 3, Dr. Moskovitz?
We compile all of the data, everything from the preclinical through the phase 3 studies, and we assess those data. We have all of the data submitted to the FDA with a proposed label based upon the data in what's called a new drug application, an NDA.
Now, we've also heard reference to an IND. What is an IND and where does it fit into this process?
The IND is the investigational new drug application. That would come after we do all of the preclinical work. It would be submitted to the FDA. In essence, it's a request to bring the drug into humans.
So in other words, before you start phase 1 testing, you submit to the FDA. What does an IND stand for?
Investigational new drug.
And then when you get out of phase 3, you submit an NDA for FDA review.
Correct, a new drug application.
What does that new drug application generally have with it?
All of the information that we've collected, all of the raw data that we've collected, which allows the FDA to do an independent analysis of any of the analyses that we might have done. It would include information about how we propose to provide the drug, the finished product, how we propose to label the drug, the package insert, the enclosure for the drug, and depending upon the specific drug, for opioids today, that would include a REMS program, a risk evaluation and mitigation strategy program. But that's specific to certain drugs where the FDA has made a determination that there are risks that need to be managed with special programs.
Between the submission of the IND allowing you to go into phase 1 and the approval of the NDA, if you get approval for the drug, is the FDA involved in any way?
Oh, yes. There are periodic meetings with the Food and Drug Administration where we share information with them and share our proposed development program. One of the most critical would be the end of phase 2 meeting where we're proposing to the FDA, this is the phase 3 program that we're proposing, and if the phase 3 program we're proposing, and here's the indication that we're proposing for marketing the drug, if the studies are positive, if they show efficacy, would these studies lead to approval for that indication?
The court has before it the NDA for Duragesic, which I think is 64 volumes, if I remember correctly. Why is there so much information in there? What does the FDA do with it?
The FDA gets all of the data so that they have the opportunity to review everything we know about the compound. I think importantly for the clinical trials, they also receive the raw data, the actual data sets of the individual patients, and they may choose to analyze those data in ways that we haven't specifically analyzed them in our phase 2 or phase 3 clinical trials.
So the FDA actually reviews the data you've submitted?
Yes, sir.
Do you have interaction with the FDA during that phase of approval?
Yes, sir. Periodically there may be a question about some of the data. They may ask us to do an additional analysis of the data. It's not just the clinical trials. There may be questions about how we're proposing to package the information and specifications around the drug.
You've given us some idea for at least Nucynta that it took roughly a decade to get through this process. How many people are involved in it from your end and from the FDA's end?
Well, certainly over the course of this, there are hundreds of individuals within the company who are involved in developing the drug, conducting the trials, analyzing the data, and compiling the new drug application. I can't begin to fathom the number of individuals on the part of the FDA, but the FDA has different groups that would evaluate the pharmacology, the pharmacokinetics, the clinical data, the specifications around how the drug is made and packaged, but I don't know how many.
You've indicated that it could, and it did take about a decade to get Nucynta to the market. How long does it take the FDA to review an NDA and make a determination whether it will approve the drug?
Well, early on, there were no specific timelines that the FDA had to meet, and it could take several years before the FDA completed their reviews and made a determination. Today, there are guidelines that the FDA meets, and I believe that for most compounds, specifically those compounds that aren't identified as bringing a breakthrough medication to market, but for most compounds, I believe the period over which the FDA reviews the NDA is 9 months.
Do you remember, specific to Nucynta, how long it took?
I believe we were close to 9 months for the review of the compound.
If the FDA approves the drug, what does that signify?
Well, with the approval of the drug, they're also approving how the drug is packaged, how the drug is going to be provided, and the package insert, the labeling information, which includes all of the information that we would be required to provide a healthcare provider on how to select the right patient, how to select the right dose for the patient, what are the contraindications, the precautions, the warnings, the educational material that might be needed when he or she interacts with a patient, instructions that he or she might need to share with the patient, the full gamut of data that would allow for the benefit to outweigh the risk.
Is phase 3 the end of it?
Oh, no.
So is there an ongoing process the FDA is involved with you as a drug manufacturer?
Yes, sir.
Have we prepared a graphic so you can explain to the court what that process is?
Yes, sir.
May I, Your Honor?
Yes. We'll mark them at the end.
Is this the demonstrative you prepared to walk through so that you can explain to us what happens even after the drug is approved?
Yes, sir.
Just go ahead and start wherever you want and explain to us what you're saying there.
Okay. Well, this is not complete by any stretch. These are some of the more frequent activities that a medical affairs group might do in phase 4. Certainly there are additional clinical trials that we would do. Again, oftentimes we know where the gaps in information might be from the phase 2 and phase 3 trials, and so we may choose to do clinical trials, as an example, against a known compound that is currently being used. So we develop some efficacy data against what physicians are using now.
Now, can the FDA also order phase 4 trials?
Yes, they can.
Okay. So if you have a phase 4 trial, is all of that information submitted to the FDA as well?
Yes, regardless of whether the FDA orders it, or we simply want to expand the body of information ourselves. All of the data that we develop will be submitted to the Food and Drug Administration.
What do you mean by, I'm sorry, are you done with
Yes, sir.
clinical trials? If I jump in and you've got something else to say, please feel free to tell me to be quiet and go on and say it. Fair enough?
Fair enough.
Next on your list, there's post-market surveillance. Tell us about that.
Well, we've already spoken about the adverse event reporting. There is an ongoing assessment of all adverse events on a worldwide basis that
When
are.
you say adverse event, what do you mean?
It's commonly thought of as side effects. There is a formal definition. These are untoward events that might occur during the course of taking one of our medications. But it's commonly thought of as side effects.
Just in this case, Janssen still has Duragesic on the market.
Yes, sir.
So what kind of post-market surveillance, if any, do you conduct on Duragesic?
If there are any reports of adverse events, whether they come from a patient or a healthcare provider, we review the literature around all of our compounds, and any information about the safety of our compounds that we might glean from the literature would be included in the post-marketing surveillance. We coordinate the post-marketing surveillance with the FDA's database because some adverse events might be reported to the FDA. They have a database as well, and we share those data.
We're going to get into a lot of post-market surveillance tools later on in your examination, Doctor, but just as a general rule, can you let the court know what tools are available there to you and to the FDA for post-market surveillance?
Well, there would be reports to us, and there would be reports to the FDA. But when we speak of post-market surveillance, depending upon the product, we may go well beyond the issue simply of what are the adverse events. When there are specific adverse events of interest to the FDA, such as for opioids, issues around abuse, misuse, diversion, we may put in place specific programs that would monitor for these adverse events, and that would be included under the heading of post-market surveillance.
And can you give the court just an example of one of those programs?
That would be the data that we collect under the RADARS group.
I'm sorry I interrupted you before you we're talking about database reviews and literature reviews, so can you just complete your thoughts on those?
Sure. Database reviews, there might be a question that would best be answered through our outcomes research group by going to a large healthcare group and analyzing their specific database to get an answer. These might be issues of looking at special patient populations. They might answer economic data. As an example of a database review, if you had a drug that might require that there be laboratory testing for the drug to be used safely, a database review might help to understand what the total cost of the drug would be to the healthcare system, not just the cost of the drug, but the cost of all of the additional monitoring that might be needed. Shall I continue?
Sure, absolutely.
Literature reviews, anything that's published around our compounds would be reviewed in the literature. That's some of the information that might be provided, if you recall the previous slide, through our medical services group to a healthcare provider if there are questions. But if there are any safety data that we understand from the literature review, that would go into the safety assessment. And finally, observational studies. These might be considered additional clinical trials, but these have, as opposed to controlled clinical trials, sometimes we want to answer the question of, if I put a patient on the drug today, what are the expectations long term? If I get to treat this patient for 3 months, for 6 months, for 1 year, for 2 years, if it's a drug that could be used that long, and simply observing the patients that I'm selecting for the study, what happens over a long period of time.
Dr. Moskowitz, if we could kind of switch gears now, we're talking in this case about opioids.
Yes, sir.
And the court has heard a lot of testimony. I don't want to belabor the point, but can you tell the court what an opioid is?
Opioid compounds are compounds that specifically attach to a receptor within the nervous system, a receptor we call the mu receptor. The mu receptor it modulates how we experience pain. And by...
Excuse me, can you stop there? You said modulate pain. What does that mean exactly?
It changes how we perceive the pain. And by attaching to the mu receptor and changing how pain is perceived, it generally reduces the amount of pain that the patient is experiencing.
Are all opioids the same?
No, they're not.
Can you tell us in some ways that they vary?
Yes, sir. To begin with, there are subreceptors. The mu receptor has certain other receptors associated with it. There are other pain receptors. Some of the opioids attach to not only the mu receptor, they may attach to other receptors that modulate pain. They also differ with respect to the potency. So the same amount of drug, if it were more potent, would bind more strongly to the mu receptor. Other compounds bind weakly to the mu receptor. And certainly they might differ with respect to what their adverse event profile might look like.
Do all opioids contain the same active ingredient?
No, sir.
Can you give us some idea of the various active ingredients that opioids contain?
Well, in addition to the opioids we've already spoken about, fentanyl, tramadol, and tapentadol, other commonly used opioids would include codeine, hydrocodone, oxycodone, hydromorphone. There are a number of compounds, some that are used only in anesthesia, would be other analogs of fentanyl, but there are a large number of opioids.
We all think of taking medicine by pill, but are there different methods of delivery for various opioids?
Yes, sir.
Can you tell the court a little bit about the various methods of delivery for these differing opioid compounds?
Yes, sir. I could almost say that if there's a way of getting it into the body, there's an opioid that can be delivered that way. We take opioids orally. We take them intravenously through a vein. They can be administered intramuscularly, an injection into the muscle, subcutaneously just under the skin, transdermally, where we're speaking of Duragesic, where there's a patch that allows the active ingredient to be transferred across the skin and then taken up by the body, and they can be given rectally.
Do all opioids last the same amount of time?
No, sir.
Can you tell the court generally how those opioids break out in terms of duration?
Well, that would depend on the opioid itself and on the formulation of the opioid. If you took the raw opioid, there are opioids that have a fairly short acting period that once injected may have activity only actually over a few minutes to a few hours. There are opioids that even the molecule itself tends to last longer in the body. That would be something like methadone. But then there are opioids where, depending upon how it's formulated, might have a longer duration of action, and those would be administered in some sort of extended release formulation.
You mentioned two words there, short and long. Is it fair to break opioids down into short-acting and long-acting just for purposes of our discussion today?
Sure. I think that in general, when we speak about short or long-acting opioids, for short-acting opioids, we're talking about opioids that are generally given every 4 to 6 hours, 4 to 6 times a day. For long-acting opioids, we generally are speaking of opioids that can be administered twice a day or even less frequently than that.
I think of long-acting medicine as time-released. Is that a fair analogy?
Yes, it's something that may be released over a long period of time, but as in the case of methadone, it's simply that's an inherent attribute of the drug itself.
So for the duration, it can be the nature of the molecule itself or the way it's formulated.
That's correct.
Now, are opioids scheduled?
Yes, sir, they are.
And can you give the court just a brief overview of what that means?
Yes. When we deal with any compound, not just opioids, but any compound that might have neuropsychiatric capabilities, where there are concerns about risks of abuse, misuse, diversion, addiction, the DEA, the Drug Enforcement Agency, and the FDA working together will require some preclinical studies that we've spoken about to assess those potentials. They have what they call an 8-factor analysis, or 8 questions they ask about these drugs, and the studies are designed to answer those factors. And based upon those factors, the DEA and FDA will agree on a schedule for these compounds.
And when a drug is scheduled by the DEA or FDA, what does that mean?
Well, if you start with the most restricted scheduling, Schedule 1 compounds. Schedule 1 compounds are simply compounds like heroin where there is no known medicinal benefit to the drug. These are drugs that cannot be sold. As you go from Schedule 1 down through Schedule 2, 3, 4, the scheduling implies that the risks of abuse, misuse, diversion are lower as you move from Schedule 2 to 3 to 4. And the restrictions on how they might be prescribed differ depending upon the schedule.
Do you have to have a special license to prescribe a scheduled narcotic?
Yes, sir. You need a DEA license to prescribe a scheduled product.
So you'd have to be a doctor plus have the DEA certificate to be able to prescribe a scheduled narcotic?
Yes, sir.
Can you give the court just some general idea of what it means to be Schedule 2?
Yes. Schedule 2 would be the most restrictive schedule for a compound, but nonetheless, as in contradistinction to Schedule 1, there is a recognized benefit to the product, but these would be products with recognized highest potential for risks of abuse, misuse, diversion, and addiction. And so how you would get these drugs would be the most restrictive. These are drugs that cannot be called into the pharmacy. You can't write for renewals. Each prescription would have to be independent. That's an example of the restrictions placed around Schedule 2 products.
And then going down the schedule, what is the least restrictive schedule number?
I think for opioids, it's a Schedule 4.
Now, Schedule 2 that you described covers which of Janssen's products?
They cover the Duragesic patch, which is fentanyl, and they cover tapentadol, Nucynta, both the immediate release and the extended release formulations.
And are you familiar with the way that, say, Duragesic works as a Schedule II narcotic?
Yes, sir.
In this case, there has been testimony about something called hyperanalgesia. Do you remember that?
I think you mean hyperalgesia.
I probably do. Can you spell that for Angie, since I can't even say it?
HYPERALGESIA.
Thank you. And when I bumble over a word, Doctor, please feel free to correct me.
Yes, sir.
Tell the court what that is. I don't think it's in there. Thanks.
My understanding of hyperalgesia is this is a relatively rare occurrence where there's a paradoxical response to increasing the dose of an opioid. That is to say that as the dose of the opioid is increased, the patient might experience more pain rather than get pain relief.
We had a witness on the stand, Dr. Maslin-Deuce, who described this phenomenon for us using a chart, which is Court Exhibit 31. Do you remember seeing that?
Yes, sir.
And this is already a court exhibit, Your Honor, so I don't, if you need another copy.
No.
Can you explain what this chart is trying to show?
My best assessment is that Dr. Maslin-Deuce was showing that with repeated administrations of an opioid, the baseline level of the pain might change so that you're getting less benefit with the opioid.
And as I recall, Dr. Maslin-Deuce suggested that people who take opioids experience hyperalgesia. Do you agree with that testimony?
Objection. Mischaracterizes.
Overruled.
Thank you.
As I stated, my understanding of hyperalgesia from the literature is that hyperalgesia is...
Excuse me, before you go on, did you see in Dr. Maslin-Deuce's testimony or demonstration any literature cited?
No, I did not.
Have you actually looked at some literature on this subject?
Yes, sir.
Okay, I'm sorry. Go ahead. I interrupted you.
As I indicated, my understanding from the literature and from my learning about pain management, it would be a paradoxical response. That is to say that as the dose of the drug is increased, the patient is experiencing more pain. That's different than tolerance, and we can talk about tolerance, but it differs from tolerance in that you are getting this paradoxical response.
And as someone who's been following a product such as Duragesic or Nucynta since their release and was in charge of the pain, do you agree with this paradoxical response in all patients who receive opioid?
No, sir. We have no data that we've seen in all of the clinical data that we've developed or in the adverse events that have been reported to suggest that hyperalgesia is seen in anything but a tiny fraction of our patients.
All right, thank you, Jim. Are there other treatments available for pain, acute or chronic, other than opioid therapy?
Absolutely.
Can you tell the court some of those that are available?
Well, starting with non-chemical intervention, non-drug intervention, there would be cognitive behavioral therapy, physical therapy, heat, massage, careful exercise. But then if we talk about using a therapeutic intervention, most people would understand and often start off with something like acetaminophen, Tylenol, or non-steroidal anti-inflammatories. NSAIDs, and these would be the aspirins, the ibuprofens, the naproxens, the Celebrex, that are commonly used, and many of them are over the counter at this time. We might then move to mild opioids. Even before opioids, there are other drugs in other therapeutic areas that have been shown to have some efficacy in analgesia, antidepressants, sedatives. But I'm talking specifically about analgesics. You have the mild opioids and then stronger opioids until you get to the strongest opioids.
We talked before about short-acting and long-acting.
Yes, sir.
In terms of people who are on a long-acting opioid such as Nucynta ER or Duragesic, had you seen data which suggests that hyperalgesia is a problem?
I'm going by the data that are reported to us and that we review in the literature, the totality of everything we have access to. And no, we have not seen that that reports of hyperalgesia with our compounds are anything less than what would be considered very rare. That's not just the adverse events that are reported to us, but this is a literature review as well.
And do you have studies that go out a period of time, give the court some idea of how long back you're looking?
Yes, sir. For both Nucynta and Duragesic, we have studies that went out for more than 2 years.
Doctor, you talked about the various things that can be done to treat pain, acute or chronic, up to and including class 2 opioids. Does failure to treat pain pose an increased risk to pain sensitivity?
Yes. In the literature, there is also a discussion of untreated pain causing, over time, even worse pain. There is what's termed a recruitment of other neurons around the area where the pain is perceived that, if left untreated, could make the duration and the severity of the pain worse and more difficult to treat if you don't treat the initial injury.
There's been some discussion in the case about failure to treat acute pain can lead to chronic pain, or is that what you're trying to get at there, or something like it?
Yes, sir. That's exactly what I'm getting to, that if you don't adequately treat acute pain, it has been reviewed in the literature, discussed in the literature, that sometimes that can progress to chronic pain, and it's thought to be because the areas around the injury, the neurons are recruited, and you heighten the sensitivity to pain.
And when you say chronic pain, do you have a definition of that?
Well, typically the definition that we use is the pain lasts for 3 months or beyond the expected period of time where you would expect the injury to have resolved.
Doctor, if we can shift gears again, we started off talking about opioids in general a few moments ago. I want to come to Duragesic.
Yes, sir.
Tell me what the active ingredient in Duragesic is.
That's fentanyl.
And what is fentanyl?
Fentanyl is a potent mu agonist. It's the opioid that binds to the mu receptor throughout the body, and it modulates our perception of pain.
Is it a powerful or potent substance?
Yes, it's considered to be a potent opioid in that very small amounts of the molecule, because they bind so strongly to the mu receptor, can be effective.
The court's already heard a lot of evidence about Duragesic and how it's used to treat pain. Does fentanyl have other uses?
Yes, sir.
Give the court some idea of some of those other uses.
Yes, sir. It's typically used as an anesthetic agent during surgery.
And are there other fentanyl products on the market other than Duragesic?
Yes, sir.
Can you give the court some examples?
Well, there are the vials of fentanyl that are used during surgical procedures. And the vials of fentanyl are also used in intravenous administration in patients who post-operatively and in a hospital setting require what's called patient-controlled anesthesia. So patients have an IV and they have something that they can press to deliver a dose of fentanyl to treat their post-operative pain. It can be administered under the tongue or placed on the inside of the cheek to deliver a dose of fentanyl as well.
You've spent a fair bit of time this morning telling the court about how fentanyl products get approved by the DEA and the FDA. Are there fentanyl products that aren't approved by the DEA and FDA?
Yes, sir. There are what are termed illicit fentanyl products or analogs of fentanyl products. Fentanyl products that have very small molecular changes, but fundamentally it's the fentanyl molecule. These are illicitly available, not through a prescription filled at a pharmacy for the correct patient.
Are these products often mixed with other illicit drugs?
Yes, sir.
What kind of fentanyl does Duragesic contain?
It's a highly purified pharmaceutical grade fentanyl that's manufactured so that it can be used in the fentanyl patch.
The court's heard a lot of testimony about poppies and growing opium. Is fentanyl derived from opium poppies?
No, sir, it's a synthetic compound.
Is the fentanyl and Duragesic mixed with any other drug?
No, sir.
Comparing illicit fentanyl and the fentanyl contained in Duragesic, how do you rate them in terms of danger?
Well, the fentanyl that's contained in a Duragesic patch is, we know exactly how much is in there. Depending upon the size and the content of the patch, it's going to be 12.5, 25, 50, 75, or 100 micrograms per milliliter. And it's highly purified. It's pure fentanyl. I have no idea what might be given outside that the pharmaceutical supply of Duragesic. It could be mixed with other drugs. It could be not pure in and of itself. It might be an analog of fentanyl.
You've already told us that Duragesic is a scheduled opioid.
That's correct.
Scheduled 2.
Yes, sir.
Is it available without a prescription?
No, it is not.
Can you get a prescription for Duragesic from just any doctor?
No, sir.
What must the doctor have to prescribe it?
He or she must be DEA licensed to prescribe Schedule II products.
And does the scheduling of a drug such as Duragesic in Schedule II impact its prescription in other ways, other than just requiring a DEA number to write the prescription?
Well, we spoke about some of the additional restrictions on Schedule II products. They can't be called into the pharmacy. They can't have renewals. You need a new prescription.
How is Duragesic, the fentanyl in a Duragesic patch, delivered?
It's delivered transdermally. That is to say, there's a patch that's put on the skin, and the fentanyl diffuses across the skin and into the subcutaneous tissue, and it's taken up from the subcutaneous tissue into the general circulation.
And is fentanyl delivered over a period of time if a Duragesic patch is used?
Yes, sir.
What period of time?
It's delivered over a 72-hour period. So patients who use Duragesic can put a patch on and then leave that patch in place and change it after 72 hours.
Okay, I don't want to get your medical nerd hat on here too much, but can you explain how this transdermal system works?
Well, yes. So there is the reservoir where the fentanyl is maintained within the patch. It diffuses across the patch and across the skin. It goes into the subcutaneous tissue where you have the bloodstream, and over time it's taken up from the subcutaneous tissue and distributed into the circulation and throughout the body.
Does the FDA-approved label, which you discussed earlier in your testimony, discuss how Duragesic delivers its fentanyl product?
If you mean by the pharmacokinetics, yes, it does.
And the Duragesic label, at least one of them from 2005, is already in evidence. Janice, can you bring up J27?
Mr. Ottaway, I'd like to stop you now so we can take our morning break.
Darn, I was just looking forward to getting into the label, too.
That will have to wait.
All right.
Let's go ahead and break until 10:30. and get started. Please have a seat.
Two housekeeping matters before we begin.
Sure.
I understand that I offered an acronym, PSURE, PATER, PBER, which is the new word for PSURE, exhibit, that there was no objection, but the court did not formally admit it into evidence.
Okay, we'll add that Duragesic, PSUR, PADER, PBRER, is that right?
Yes, it's apparently the new name for one of the others.
Okay.
Your Honor, I don't believe this was offered. I think that Mr. Ottaway went through the Duragesic NDAs and similar acronyms for Nucynta. I don't believe this one was actually offered. I don't have an issue with any of them except for the witness testified he didn't know what PBRER reports even were. And so I don't believe that any foundation for those has been laid yet. Again, you ask him the questions and he can establish what they are. I don't have a problem with it, but just offering up exhibits that we haven't proven up, I don't think that's not how we do it.
If your objection is to the PBER one, Drew, it's just a new name for PSURE, but
And I think the witness testified to knowledge of PSUR, PSUR.
Okay.
So you're saying that those acronyms are the same?
they're
Distinct.
continuations of one another.
Okay.
And I did offer it, and there was no objection, but there was no ruling admitting it into evidence according
Sure.
to my
Well,
exhibit.
we'll note Mr. Pate's objection, or you said there's no objection so long as
Not
there's
really an
foundation.
objection as long as the witness actually can
Yeah,
testify to what
I believe he did, and those will also be admitted into the evidence. And those are, I think, well, they start with J0694.
Correct, Your Honor.
They don't go consecutively, but that's the lowest number, and I think the highest number is J2680.
Correct, Your Honor.
And I will probably get the privilege of listing the numbers before the break.
Yes.
Thank you.
And as I understand it, the court has admitted the IND and NDAs for Nucynta and Duragesic, Nucynta ER
Yes.
already, so. Sorry, again, Dr. Moskowitz, for the housekeeping. You had told the court what fentanyl is. As I recall, you told me it is a potent substance.
Yes, sir.
Why in the world use fentanyl in this Duragesic patch?
Well, because of its potency, we were able to design a patch where we could use very small amounts of the fentanyl in the patch. If we ostensibly used something that was less potent, either we couldn't develop a patch or it would be quite large.
And why a patch?
For one thing, this was a new delivery system. It offered certain advantages over the existing delivery systems.
Let's say I can't swallow a pill. Is there an advantage to having a patch?
Yes, sir. Early on, it was recognized that this could be a delivery system for patients who couldn't take anything orally, but it also allowed us the extended release to deliver fentanyl over a 72-hour period.
Let's say, and I take it, we're getting ready to get into the label. The way you're supposed to use the patch is described in the label.
Yes, sir.
What if I altered that method of administration? What if I, instead of putting it on my skin, ate it, for example? What would happen to the delivery system and this fentanyl that's in it?
Well, clearly the package insert warns against tampering with the patch in any way, but if you were to try to get to the fentanyl through any means other than the standard prescribed transdermal delivery and defeated the system, you could die. There are serious adverse events that could be associated with it. If you got too much of a dose of fentanyl, it would lead to respiratory depression and potentially to death.
As I understand it, there is a 72-hour dose of fentanyl somewhere in this patch.
Yes, sir.
So if you get it all at once, what is the result of that potential result?
Well, instead of getting the very small amount that would be delivered on an hourly basis across the skin, and you're getting it all at the same time, the most serious risk associated with that would be respiratory depression and death.
Okay, we'll get into that a little bit more as we get into the label, and I'm not going to go through all the labels with you, Doctor, but let's pull up, if we can, the Duragesic label for 2005, which is Exhibit 2769. Mr. Pate, already in evidence. Do you recognize that?
Yes, sir.
And can we blow that up, just the for use in opioid tolerant patients? What is this telling us, Dr. Moskowitz?
That you should only be using a Duragesic patch in an individual who has already been receiving an opioid for some period of time at some dosage that would allow you to then decide what the right dosage of fentanyl would be. You could not give this to an individual who is what we call opioid naive, has never received an opioid or has not received an opioid in an extended period of time.
You talked about indications for this product being
Yes, sir.
established by the FDA.
Yes, sir.
Can you move that up just a little bit, if that's possible, Ms. Conway? When I see the word indicated, is that what you mean by indications?
Yes, sir. That's when I'm selecting the patient for whom I'm going to be using the patch. This is the indication, the disease process that the patient must have.
And when we were talking about the method of administration, is that listed there in those bullet points?
Yes, sir.
Now, you talked earlier about pharmacokinetics.
Pharmacokinetics.
See, doggone it. Pharmacokinetics, Angie, I'm sorry. And I think that's discussed on page 5.
Yes, sir.
Yep, there's that word. Pharmacokinetics. And is this what you're referring to earlier in your testimony on that subject?
Yes, sir.
And can you just remind us briefly again what that means?
Yes. We were talking about how the pharmacokinetics encompasses ADME, absorption, distribution, metabolism, and excretion. Fundamentally, how the drug gets into the body, what happens to it in the body, what are the concentrations, how does the drug get out of the body.
The reason I raised this with you, Dr. Moskowitz, is there was some earlier testimony about a graph on page 6, and I want to direct your attention to it. Does this graph, following the pharmacokinetics section, discuss the pharmacokinetic effect of Duragesic?
Yes, sir.
Can you tell us what this graph is showing?
Yes, this would have been one of the phase 1 trials, the trials in normal volunteers, and to assess the pharmacokinetics, the concentrations of fentanyl in the body. And we're seeing here one aspect of the pharmacokinetics. This was a study that was done to determine the concentrations following multiple applications of Duragesic, that is every 3 days, at the highest dose, although we have data for all of the doses. The highest dose was 100 microgram per hour. That's simply the highest dose of the patches that we supplied in normal volunteers.
Does this graph depict the serum fentanyl concentration in just one subject or person
No, sir.
after just one application?
No, sir.
Well, explain to me what it means to reach a steady state with this product.
Yes, sir. Steady state is a statistical determination that a successive dose is giving you the same concentrations as the previous dose. That over time, once you reach steady state, with each dose you're taking, you're getting roughly the same plasma concentrations as you got with the previous dose.
Earlier, we spoke of the testimony of a doctor who testified earlier in this case named Mazumdus. Do you remember that?
Yes, sir.
He had some opinions about this graph. Have you reviewed those?
Yes, sir.
Do you agree with those opinions?
I do not.
And can you tell Judge Botman where you think he went wrong?
I believe in his testimony he indicated that this graph shows that there are peaks and troughs for fentanyl, and that therefore it is not delivering a constant amount of drug over a period of time.
And why do you disagree with that when you've got all those little things, the squiggly lines going up and down?
Well, for one thing, we're not seeing the data here for any single patient. This is a compilation, any single subject. These are normal volunteers. We're not seeing the serum concentrations for any single individual. We're simply seeing at the height of this graph the highest concentration at that time point that might have been seen with any individual, and at the low end, the group, the minimum concentration that might have been seen. There is no representation here of any individual subject. And the middle dotted line is the average across all of those subjects. We're also seeing here only the 100 microgram per hour patch, and we have data for each of the other patches as well.
Now that graph has a scale on it at the bottom and the top. Can you explain to the court the significance of those, if any?
Yes. Along the x-axis, you're seeing when the drug was applied and taken off. So beginning with day 1, there's no patch. Now we're applying the first of the patches, and then on day 4, day 7, day 10, and then day 13, every 72 hours, every 3 days, we're removing the patch that was on the patient and at the same time putting on a new patch. And that continues. We measure the concentrations then without changing that patch from day 13 through day 14, day 15. Day 16, we're removing the last patch and determining the serum concentrations now as they fall off, because we're no longer putting on a new patch. The y-axis is the serum fentanyl concentrations that we're measuring in the blood.
And again, the grayed out area on the chart?
Simply represents the totality of all the data, the highest concentrations we may have seen for any individual patient at that time point, and the minimum concentrations for any individual patient we may have seen at that time point. We know that there are variations, but within an individual patient can be titrated to a dose that provides the pain relief and we hope is well tolerated for that patient, and provides that serum concentration, not identical over the 72-hour periods. There are fluctuations, but it can be maintained over the 72-hour period.
Look at day 13 with me, if you will. It's kind of the broken area there right before the big peak. Dr. Mazumdus, I recall, testified a single patient received a double dose of fentanyl on that day. Is that an accurate representation of what that chart reflects?
I don't know what he means by a double dose. There was a subject who had a peak at the time of approximately 4.5 nanograms per milliliter.
Okay, and tell me, again, this is an average. Is that what the dotted mean there is?
Yes, that's correct. You're taking all the subjects and you're looking at the average concentration at each of those time points.
And did the FDA, when it put this chart in the fentanyl label, have all of the data for all of the subjects reflected in that chart?
Yes, they did.
Do you believe that this chart misled doctors?
No, sir.
is there some reason that the entire chart was shown this way as opposed to depicted in some other fashion?
Generally, we are showing the highest dose that we would be studying. There are other tables which show concentrations for each of the systems, of the transdermal systems, but typically you would see the greatest variation with the highest doses. But again, the individuals who would be at the highest dose would need to be titrated to that dose, and they would not be started on that dose unless they were already receiving either lower doses of fentanyl or equivalent doses of another opioid.
Now, I believe that this chart is reflected as a mean line and some other information that Janssen provided.
Yes.
Why did you use the mean line as opposed to just reprinting the entire graph?
Typically, we would give a mean because ultimately every individual patient is going to have some serum concentration, but it gives some information to the physician about what he or she might expect. Nonetheless, the physician needs to cautiously titrate the patient to whatever dose might be appropriate.
And did the FDA agree that this is the chart that should accompany the label?
Yes, sir.
Is that reflected in that section we were looking at before? If you can bring back to page 5 again. And starting with that following, if you go down a little bit, Janice, you're free to look at any of this you want to, but I want to call out that following Duragesic application because that's what we're talking about in the chart, correct?
Yes, sir.
And can you tell the court what this tells you and the reader about that chart?
Yes, sir. So as I indicated earlier, Duragesic is transferred across the skin, and it concentrates in the upper layers of the skin, and then from the upper layers it's taken up by the circulation, by the systemic circulation. As we've seen on the graph, the concentrations increase gradually following the initial application of Duragesic, and they generally level off between 12 and 24 hours and remain relatively constant, not identical, but relatively constant with some fluctuation for the remainder of the 72-hour period that the patient is wearing the patch. The highest concentrations generally occur between 24 and 72 hours after the application. They're proportional, which is to say that the concentrations that you're going to see with the 50 microgram patch are roughly twice what you're seeing with the 25 microgram patch. The 100 microgram patch is roughly 4 times the 25 or twice the 50.
And referring to the last sentence in that section, what is that telling the practitioner?
After several sequential 72-hour applications, patients reach and maintain steady state concentrations that's determined by individual variation. So we spoke about steady state. That is to say that after several applications of the patch, the patient will continue to get a serum concentration with each successive patch that roughly mirrors what he or she had received with the previous patch.
You mentioned the 100 milligram patch a moment ago.
Microgram.
Micrograms. That's right. You keep me on the straight and narrow there, Doctor. Is that the only dose this product comes in?
No, sir.
If I use the term initiating dose, what would that mean to you as a physician?
The initiating dose would be the dose that I, as a physician, might select as the dose I'm going to put my patient on after making a determination that my patient otherwise meets criteria for moving from another opioid. Remember, none of the patients can be opioid naive, so they're already on another opioid, and I have to select what the right dose to move this individual from to a patch of Duragesic.
I've heard the term in this case titration. Is that what we're talking about?
Well, that's not the initiating dose. The initiating dose is looking at essentially how much drug, how much of an opioid the patient is on at the time I switch them over to Duragesic. And you've heard the term, I know, of morphine milliequivalent. So there is a way of determining roughly how much opioid a patient is getting today, and therefore making a conservative judgment about what the first dose of Duragesic might be. Subsequently, I may need to titrate the dose depending upon the pain relief the patient is getting and how well the patient is tolerating the drug, and I may need to make some adjustments in that first dose.
And again, as we wrap this subject up, why use 10 patients and an average as opposed to just one patient?
Well, you would not get a good idea about the range of plasma concentration, serum concentrations that you might see with one individual subject. There are statistical determinations that help us understand how many subjects we would need to enroll to the study to get a good idea about the pharmacokinetics of the drug.
In your opinion, as a practitioner and a physician, is there anything misleading about that?
No, sir.
Now we'll switch gears, if we can, to the design of Duragesic.
Yes.
And you've already given a copy to Mr. Page. I want to talk with you, Doctor, for a moment about the design of this transdermal system that you have discussed. And did we prepare a graphic to help you do so?
Yes, sir.
Can you please explain to Judge Bachman the various designs that have been incorporated in a Duragesic patch, why they're unique, and what the purpose of them
Yes, sir.
is?
The first schematic shows the Duragesic patch that was marketed and sold between the approval and 2009. It was what we call a drug in a gel reservoir. If you looked at the patch, you'd actually see kind of a little bit of a liquid in a plastic lining. The backing, the drug in the gel, then there would be a membrane that controls the amount of fentanyl that is released into the upper layer of the skin. There's a contact adhesive that allows the Duragesic patch to adhere to the skin, and then it goes into the skin.
Well, what happened in 2009 regarding the design of this transdermal system?
Yes, over the course of this time, there were other ways of designing the patch such that you could now allow the drug and adhesive to be in a single layer. And so now you just had what we termed a matrix patch, where you had the backing, so you wouldn't have fentanyl exposed, but then the drug in the adhesive directly over the skin.
Were there advantages to the reservoir system?
Yes, there were.
Can you tell Judge Bachman some of what you perceive the advantages to the reservoir system to be?
Well, one of the things we came to understand was it was difficult to extract a specific amount of fentanyl. If somebody wanted to get exactly some dose of fentanyl, you couldn't readily know what you were extracting would be that dose. The fact that it was in a gel reservoir also made it very viscous. It was very difficult to extract the fentanyl from the transdermal patch. It was very difficult then to put it into some form where it could be injected or to snort whatever you withdrew from the patch.
Was it impossible to abuse?
No, sir. Nothing is impossible to abuse.
And how would that occur?
We still had patients who would cut the patch to get at the at the drug. They would try to put multiple patches on. They could certainly get the fentanyl by doing so. We know that there were attempts to chew the patch or to smoke the patch.
And so what did you do in response to those reports, if anything?
Well, we certainly understood the ways in which it could be done, and we warned in our labeling about not to use the patch in any of those ways because you could get a fatal dose of fentanyl.
Did you engage people to assist you in determining how to reduce the abuse potential of the reservoir system?
Yes, sir.
Can you tell the court about that?
At the time that we were considering whether to move to a matrix patch, this is around 2001, we wanted to understand whether there were potential benefits or risks associated with one or the other formulation of transdermal fentanyl. We heard from our advisors that there were potentially risks associated with the matrix patch that we wouldn't have with the reservoir patch. Specifically, now that you have a drug and adhesive, you could take the patch and cut it into discrete, smaller pieces of the Duragesic patch. And now you could take a 100 microgram patch, cut it into 4, and make 4 25 microgram patches. It might be easier to transport. And worst, we were concerned that it might become used as party dots.
Now, you say you retained some consultants. Who were they?
These were some of the individuals in the pain management group. They would include physicians who treat patients, physicians who were schooled in areas of abuse, misuse, diversion. How would an individual who was seeking to abuse or misuse the patch do so? We had experts from the DEA and from regulatory agencies.
Do you know the PINNEY Penny Group?
Yes, sir.
Can you tell the court what that is?
Yes. There was a group called Penny Associates that we engaged in 2001 to help us understand exactly these potential risks between the Duragesic patch and the reservoir patch and the matrix patch. And they were the ones who analyzed all of the environment and the potential for these risks.
Did they prepare a report?
Yes, sir, they did.
Let me approach, Your Honor, if I may.
You may.
Hand you what has been marked as J752 and ask you if that is a copy of that report.
Yes, sir, it is.
We'd offer the J752 into the evidence.
J752 will be admitted.
Can you please just read the cover of that document so that the court will get its footing on what it is?
This is D-trans fentanyl, a summary of benefits and risks, abuse and diversion, prepared by Penny Associates for Janssen Pharmaceutical and Alza Corporation, December 17, 2001.
Now, 2001 is roughly 10 years after Duragesic was first introduced into the market.
Yes, sir.
Let's look at page 29 if we could. And you're free to call out any page in between you want. Is there something on page 29 we need to call to the court's attention?
Well, they start off with their assessment of the current environment, where they state the abuse of illicit fentanyl medications appears to be quite low.
And this is discussing the current design of the patch, correct?
Yes, sir.
And how did Penny and Associates describe the misuse or abuse they found in the reservoir system? I guess it's highlighted up there.
Yes, that the reservoir system, the licit fentanyl that was available as a transdermal patch appears to be quite low.
Did that match your experience?
Yes, sir.
Hand you another, if I may, Your Honor.
Yes, you may.
J862, sticking with this consulting group. Ask if you can identify that.
Yes, this was a follow-up report by Penny Associates on an assessment of abuse potential of fentanyl transdermal systems in the United States, dated September 27, 2003.
We'd offer J862 and that.
Any objection?
No objection, Your Honor.
J862 will be admitted into the evidence.
Thank you, and again, you're free to bring anything to the court's attention you want, Dr. Moskowitz, from this report, but I want to call out page 21 to you. And discuss anything on that page that talks about the abuse potential of the Duragesic patch.
Went to exactly what I saw over here. Again, here too, this is the follow-up report in 2004. They speak in the middle. In practice, it appears that rates of abuse of this system have been relatively low, presumably due to the relative unattractiveness of an intact transdermal system for delivering the drug. The slow onset of effect compared to the rapid onset of preferred forms of fentanyl for abuse, and the relative difficulty of extracting and purifying the fentanyl from the form-filled sealed technology, as compared to readily accessible fentanyl in abusable forms, such as injectable pharmaceutical fentanyl, as well as ready accessibility of other opioids.
Did Janssen, we're in 2004 now, if I recall the date correctly, did Janssen receive other reports over this time and later, besides the one from Penny, that had similar information about the rates of abuse for Duragesic?
Yes, sir.
Another acronym for you, PDRC?
Yes, sir.
What is that?
Well, this was a group that was conducting surveillance on our behalf that looked at rates of abuse, misuse, diversion of fentanyl.
Prescription Drug Research Center?
That sounds right.
And what is, again, the PDRC for the benefit of Judge Bachman and counsel?
This was outside independent groups that we engaged to perform surveillance and assess risks of abuse, misuse, diversion of fentanyl, and those risks compared to other opioids.
Let me hand you what will be marked, or has been marked, as J907, may I, Your Honor?
Yes, you may.
Advise the court what that is.
Yes, this is a report from the PDRC, from the surveillance program that they were conducting for us over a period of time. That period was from September 1st, 2004 through January 31st, 2005, and The report came to us in May of that year.
Now, again, Dr. Moskovitz, you feel free to pull out any part you think important to talk to the court about, but I would like to call out page 7. That discusses the components of the Duragesic surveillance system. I think it's 2.2.
Yes, sir.
And how does that describe the components of the Duragesic surveillance program?
That there was more than one method by which we were trying to assess risks of abuse, misuse, and diversion. We used several sources to collect this information.
We'd offer J907 into the evidence.
No objection.
J907 will be admitted into the evidence.
And may I approach and just do 3 at once here?
Yes.
I'm going to hand you what has been marked as J908, J909, and J919.
Thank you.
Copy of each report here. What are these?
These are additional reports over different periods of time from the Prescription Drug Research Center.
Continuations of that first one that is on the board and has been admitted into evidence?
Yes, sir.
We'd offer J908, 909, and 919 into the evidence.
No objection.
J908, J909, J919 will be admitted into the evidence.
Thank you, Your Honor. Now again, how did the PDRC monitor for abuse, misuse, and diversion of Duragesic?
They had several programs that were not necessarily overlapping, where they used a sentinel network, a panel of field experts who could provide immediate notification of events that would indicate abuse, misuse, diversion, existing data sources. So there was the DAWN database that I know has been spoken of here that compares rates of abuse of Duragesic in the emergency room setting. A national monitoring program where we look at a variety of databases, which would include such things as LexisNexis, Google News, and others, to determine whether there are mentions of Duragesic relative to abuse, misuse, and diversion. And a rather innovative program for the time, we began a program looking at internet monitoring to understand in what ways individuals who sought to abuse the drug might access the drug and how they were potentially abusing the drug.
How would you do that?
I can't give you the specific details. I'm not the technology person, but they designed a program where they could look for specific terms that might be used, and using those terms, gather the type of information that they would then synthesize to understand how the drug was being misused or abused.
If I can call out, and again, you're free to go through there and point out to Judge Bachman anything you think important, but I want to call out the executive summary on page 3. the first paragraph, what do you find, if anything, informative about that?
Well, to begin with, they reviewed 14 years of data at this point, that's since the drug was brought to market. And they concluded that Duragesic, the pharmaceutical product, has had a remarkably low abuse level during all of this time.
All right, sir. You can set that aside for a moment. And did you ultimately make the switch from the reservoir system to the matrix system?
Yes, sir, we did.
And I know you've already described to Judge Botman what those systems are. What was the purpose of that switch?
When we did an assessment of the reservoir and matrix in 2004, and because of the potential for greater risk in switching from a reservoir to a matrix, we knew that there would be a matrix coming to the market as a generic in 2005. But given our concerns about the potential for the drug to have higher risks if we move to a matrix formulation, to be able to cut it, and more specifically to have it used as party dots, we made the decision at the time not to move to a matrix patch. It was only later on, around 2007, 2008, when we reviewed all of the data we had now over a 3-year period or so where the matrix was on the market, and in fact did not see the kind of rates of abuse, misuse, and diversion that we were most concerned about. Once we were satisfied that we weren't seeing those increased risks, at the FDA's urging, we moved to the matrix patch, in part because it is easier to make and it couldn't leak. We did have a couple of episodes where the patch leaked in manufacturing. We had a recall of the patch. The matrix patch can't leak.
Doctor, what are party dots?
Potentially, an individual could take a matrix patch with a hole puncher and punch small amounts of the matrix patch with small amounts that then could be chewed, and they could get the fentanyl through what those were called party dots.
Anything else, Your Honor? Okay. We talked for a moment when we looked at the product label about the indication for Duragesic.
Yes, sir.
And have we gone over and prepared a label timeline to kind of synthesize the indication for Duragesic?
Yes, sir.
From the time of its introduction until the present?
Yes, sir, we have.
May I, Your Honor?
Yes, you may.
Thank you.
And oddly enough, we have labeled it the Duragesic label timeline. Can you put that up for us, Janice? I'll offer it as court's exhibit next.
Thank you.
What are you trying to tell Judge Bachman with this demonstrative?
Well, as we learn more about the product over the time period after the drug is brought to market, we learn more about the risks, adverse events, problems that might come up. And we don't have necessarily the same package insert that we had when we brought the drug to market. As we learn more information, we will change the label to reflect the additional safety or efficacy or any additional information that might be gathered. And so over the course of the period of time that Duragesic was on the market, we've had several label changes.
When a label change is made, I think the court heard testimony earlier, is there a letter sent to physicians telling them there's been a label change?
Yes, sir. We would send a Dear Doctor letter informing them of the new label and what's changed from the previous labels.
And how has the label changed over time since introduction in 1990? And the source documents there, Your Honor, are the Duragesic labels that were previously admitted into evidence and were contained in the big binder that the court already has.
Thank you.
Well, there have been quite a few changes over that period of time. For one, we moved to having a black box, and the black box contained more information over the period of time. There was a period where we brought a new dosage form to market. That was the 12.5 microgram patch, which we, for the purposes of the label, we call the 12 microgram patch. There were increased warnings, precautions as we learned about new risks, particularly risks around heat being applied, and so we advised patients not to apply heat or use a sauna or go into a hot tub with the patch. There were changes in the indication. We're moving from the earliest approval around moderate to severe chronic pain. Eventually we moved to pain that is severe enough to require persistent around-the-clock opioid medication in an individual who has already been on opioids. We spoke about opioid-naive patients not being able to take Duragesic, and that they should have been tried on other medications, other modalities to treat their pain, and they would have and not tolerate or fail those other modalities.
You've got several areas there that are covered by each label. For example, the indication is not among them. Did the indication on this product change? Was it always the same?
No, the indication consistently focused on exactly the type of individual for whom the benefits outweigh the risks. And as we and the FDA learned of the benefits and risks associated with the product, they do a balancing act that tries to maintain the benefits while they're minimizing the risk, and that includes changes in the indication.
One of the things on that, and the court has seen a lot of these labels, and we've gone through a lot of them in terms of the benefits and risks, but what do you mean by patient selection?
Well, there has to be a careful assessment on the part of the physician when he or she is deciding how best to treat the patient with pain. And they have to first make a decision whether the patient is a valid patient to receive Duragesic. We already said this would have to be an individual who's already on an opioid. The physician would have to assess what are the other medications the patient is on. So are there any other medications that might increase risks if I started that patient on Duragesic? What are the risks based on the background of the patient? Does this patient have any history of substance abuse that might increase certain risks if I choose to put the patient? So it's the totality of the information that goes into the decision whether this is the right drug for this patient.
Janice, can you let's just pick 1994 there, J2765. And there's the indications and usage section you were discussing, and what is this product indicated for in its FDA-approved label?
It's indicated for the management of chronic pain in patients who require continuous opioid analgesia for pain that cannot be managed by lesser means such as acetaminophen, opioid combinations, nonsteroidal analgesics, or as needed PRN dosing with short-acting opioids. And it goes on to who should not receive Duragesic.
Now, you discussed patient selection before. Is that also in this label?
Yes.
And do you know how patient selection is described? talked about pain that cannot be managed by lesser means. What does that mean exactly?
The physician is instructed to assess whether the individual's pain might be managed by other interventions with lower risk than a Schedule II product such as Duragesic.
You also indicated that Duragesic was not meant for opioid-naive patients.
Yes, sir.
Tell the court what that means.
Yes, individuals who have not been exposed to an opioid ever or for an extended period of time are very sensitive to the effects of the opioid, and any of the risks and adverse events that are associated with the opioid might be magnified in that patient population. So you could not put an individual, or should not put an individual who has not already been on a specified dose of another opioid on Duragesic. You want to minimize the risks of serious adverse events by making sure that the patient receiving Duragesic has already been receiving a similar dose of another opioid compound.
Said another way, you would not start a patient, non-opioid taking patient on this product.
Correct.
And does the contraindication, because there's a contraindication section in these labels as well, make it improper to prescribe a drug to someone who is not already taking an opioid?
Yes, sir. A contraindication is saying absolutely do not use the drug in an individual who has these contraindications.
And I take it that's part of the label that may change over time as well?
Yes, sir.
Let's bring up the 2005 label. This is 27, if I could read that, 69, is that? And is this a portion of the label that you were just describing for the court?
Yes, sir. There is also a section on contraindications, but you are telling the physician if do not use the drug in a patient who cannot be managed by other means such as nonsteroidal analgesics and other potential interventions, and only to use it in patients who are already receiving opioids.
All right, and I think the last one up there was 2000. My memory is being stretched. 2014,
Sir.
J. Can you read that for me, doctor?
J2774.
Can you bring that one up so we can compare that one? And is this indication for usage slightly different than the one we looked at before?
Yes, sir.
And can you tell the court how you view this change and why it was made?
Yes. The indication here is for the management of patients in opioid-tolerant patients, which we've spoken about, severe enough to require daily, around-the-clock, long-term opioid treatment for which alternative treatment options are inadequate. This is a further strengthening of the indication from what we previously had seen.
Is the 2014 Duragesic label the one currently enforced?
Yes, sir.
So this is the one that would accompany a product or appear in the physician's desk reference current?
Yes, sir.
Is it uncommon, Dr. Moskovitz, for labels to change?
No, sir. As I've spoken about, the FDA makes a continual assessment of the benefits versus the risks of the product. Though as they learn of potentially new benefits or new risks, that ratio between the benefits and risks may change. Sometimes the risks simply outweigh the benefits, and the FDA may choose to take a drug off the market. But to the extent that they can manage the risks through something like a change in the label, they would do so.
Is the fact that these labels, and the last one, 2014, still applies to Duragesic being sold today and permitted to be sold today by the FDA, an indication that in its judgment, the benefits outweigh the risk?
Yes, if the FDA had made a determination that the risks no longer outweigh the benefits, they have the right to ask that the drug be removed from the market. But the fact that it remains on the market, they believe that with the appropriate labeling and the programs around how to use the drug properly, the benefits to the intended patient population outweigh the risks.
Doctor, has this product, Duragesic, always been approved for chronic pain as
Yes.
described in the label?
Yes, sir, although the definition of chronic pain, as we've seen in the 2014, is now persistent around the clock, severe enough to require. But it's always been chronic pain.
And has the product ever been meant or promoted for everyday, in air quotes, pain?
I don't know what the term means because it doesn't have a specific definition, but no, it was never promoted in any way for everyday pain.
Always for chronic pain as defined in the label?
Yes.
All right, let's go to the development and approval of Duragesic, if we could. When you joined medical affairs in the year 2000, did you familiarize yourself with the history of Duragesic?
Yes, sir, I did.
How was that drug developed?
The development was done by ALZA Corporation. That's a group that had special expertise in formulations, especially around transdermal formulations. This was in response to a government agency that actually called for development of new opioids to treat chronic pain. ALZA developed the compound using fentanyl because it was potent and could be delivered in a transdermal system that was reasonably small enough to be used as a transdermal system. They did much of the early work around the drug.
When Duragesic came out in the early 90s, what were the other common routes of administration for fentanyl?
It was administered intravenously for surgical procedures.
And was there an oral route of administration?
No, sir.
Okay. You said IM or intramuscularly.
Correct.
Was there an intravenous route?
It could be administered intravenously, yes.
But both of these would require somebody to inject the drug, correct?
Yes, sir. You would require additional healthcare professional to administer the drug. In the case of an intravenous, you would need an intravenous line to infuse the drug. In the case of intramuscular, there were problems associated with intramuscular administration, such as pain at the site of the injection, but you'd still need someone to inject it.
Now, we've already talked about why fentanyl was chosen for use in the transdermal patch, and we've already talked about the advantages of transdermal delivery.
Yes.
So I don't want to go back into those, but and we've already talked about how this drug was always approved for chronic pain. But what populations were used to test Duragesic in its initial phase 1 studies?
There were two populations that were used to test the drug. It was tested in a valid model of postoperative pain, where we have a clearly defined level of pain, and in patients who had pain associated with cancer.
And why were those two groups chosen?
The postoperative pain model was a well-known model where after a surgical procedure you could expect to have a certain level of moderate to severe pain for some period of time that would allow you to assess the effectiveness of the drug over that postoperative period. In the case of treating patients with cancer, They were the largest group at the time that was for which opioids were used. And again, you could determine the amount of opioid needed to effect relief in that population.
And was the safety and efficacy of the drug studied in those trials?
Yes, sir. There were other trials that were done that were not considered the pivotal trials, and the safety of the drug was assessed in any individual who would have received the drug.
Were there additional studies done?
Yes.
Tell the court about those.
There were additional studies done in specific other indications, in indications of low back pain, in osteoarthritis. We looked at longer-term treatment with Duragesic.
And did the FDA approve that drug?
Yes, sir, they did.
Okay, I got a big one for you here. Maddie. What is J2843?
This is the review on the part of the Food and Drug Administration of the new drug application.
And as a medical officer and reviewer of this kind of report, what does this tell you?
This is the FDA summary of their review of all of the data that we submitted to support the claim that we were seeking in the package insert.
We'd offer J2843 into the evidence.
No objection. J2843 will be admitted into the evidence.
And I'm not going to have you read the entire document before launch. And you are free to refer to anything in that document you wish that you think Judge Bachman needs to see, but I would like to call out page 2 and ask what that is and if it contains any significance to you.
I would go directly to the paragraph that begins, "We have completed the review of this application, including the draft labeling which was submitted, and have concluded that adequate information has been presented to demonstrate that the drug product is safe and effective for use as recommended. Accordingly, the application is approved, effective on the date of this letter."
And what does that tell you, Doctor, as someone familiar with this process and familiar with this product?
Yes, sir. Again, the FDA and the healthcare community understand that there are risks associated with every product, but the FDA's responsibility is to assess whether the benefits outweigh the risks. And so in approving the product, there would have been a determination that the benefits of the product in the intended population with the labeling provided would outweigh the risks associated with the product.
And I don't want to go into great detail, Doctor, but we've discussed a number of things that are looked at when a drug is approved, and I want to make sure that those are contained in this exhibit, just in general. For example, the efficacy indicated of the drug.
Yes, sir.
Page 107 is that a section that discusses that.
Yes, sir, that's the medical officer review of the efficacy trials.
And if I went to page 246, we have the pharmacokinetics
Got it.
discussed that you've previously told
Yes,
Judge
sir.
Bachman about.
Yes, sir.
turn to page 271, I could see the meta-analysis and cross-study comparisons that you discussed earlier in your testimony.
Yes, sir.
If I went to page 305, I could see reports regarding safety.
Yes, sir.
If I went to page 331, I could see reports on abuse and diversion.
Yes, sir.
And doctor, looking at, that's page 331, I believe. I'd like to call out, but you're free to, again, look at anything you want, page 332, and ask you what, if any, significance this document has to you.
Well, the FDA calls out here that fentanyl is not currently a drug of abuse for the general population, although they recognize then that there's a persistence of clandestine synthesis and illicit distribution, showing that it is a desirable drug of abuse.
They go down and say there's some questions that have to be answered, starting in that paragraph, the TTS.
Yes,
What does TTS mean?
transdermal therapeutic system.
And those questions are listed there,
Yes, sir.
along with the risk of abuse of transdermal therapy systems.
Therapeutic system, yes,
Therapeutic
sir.
systems when used as directed.
I think you can simply say Duragesic anytime you see TTS. That's exactly what it refers to.
And then there's reference to a meeting. What's that about?
Yes, they talk about a meeting that was held in February of 1990 among the FDA, the National Institute of Drug Abuse, and the DEA, because they would make a determination about risks of abuse, misuse, and diversion. And it is the outcome of that meeting to address those questions.
And if we go over to page 336, is there a conclusion section?
Yes, sir, there is.
Can you put that up for us, Janice, so we can see it? And doctor, what is the conclusion offered in the abuse and diversion section in that paragraph or any other paragraph you want to talk about?
Sure. They recognize that there was a significant concern regarding the possibility of abuse associated with the Duragesic fentanyl, but the data presented by the sponsor suggests that the risk to addicts, healthcare professionals, and the general public from the new dosage form is minimal. There is no bar to approval of the transdermal therapeutic system, fentanyl, on the basis of excessive risk or abuse or diversion.
Now I want to call your attention to a paragraph that starts out as fentanyl is currently a Schedule II. Can you bring that up, Jeff?
Yes.
Yeah, just a continuation of what we were looking at. And can you tell us the significance of this paragraph?
Yes. They recognized at the time fentanyl was a Schedule II product, but they also look at the formulation that we're providing the drug in, and they indicated here, although it might be argued by the sponsor that the system should have a less restrictive Schedule III classification, although it was already a Schedule II classification. Consideration might be given to such an action for the TTS dosage form of fentanyl as part of an ongoing policy to enhance the attractiveness of less abusable alternatives to parenteral morphine in medical practice, parenteral being administered orally.
Despite that language there, did
We're having a
Jan-
hard time hearing you. If you'll put that
Oh, I'm sorry.
microphone
Okay,
against
I'm
you
sorry,
when you're
sir.
looking.
I'm usually the one that needs to speak up, but if you turn away from them, it gets hard to hear you, doctor. So please try to stay in the microphone. I'm sorry, you were completing your answer.
That's okay. They indicated that based on the formulation, it might be argued that the Duragesic formulation would have been considered as a Schedule III product instead of a Schedule II product. Ultimately, it came to market as a Schedule II product.
And did Janssen ever try to have Duragesic status changed from Class 2?
No, sir.
Your Honor, I hate to break a little early. We can come back a little early if that's right, but I'm hitting a point where I'm going to change gears.
Sure. We'll take our lunch break early today, and we'll just start at 1 o'clock.
Thank you.
All right? Thank you.